And now, for today's topic, here's attorney Kevin Crayon.
Constructive discharge, involuntary forced retirement. Can I bring a case if I quit because I felt like I was forced to quit? The working conditions were so intolerable that the reasonable person would have no choice but to retire or resign. You may have what's called a mixed case. You can show that discrimination was one of the causes, and the Merit Systems Protection Board, or the MSPB, will consider the totality of the circumstances. Did the employer make the employee's working conditions so difficult that any reasonable person in the employee's position would feel compelled to resign? They have to be wrongful actions that created intolerable working conditions. So just because your job is hard, that doesn't qualify. It has to be wrongful actions, like discriminatory actions, for example. For involuntary retirement or resignations, constructive discharge, the burden is even higher than regular hostile work environment. I mean, the conditions have to be so intolerable that a person just feels compelled to resign. For example, you have a disability and you're not being accommodated, and they're exacerbating your disability. Of course, nobody is going to stick around in a place that is, making their health worse and refusing to, in good faith, accommodate, combined with maybe other wrongful actions. So that could be an involuntary resignation claim. Basically, they treat it like a termination or a discharge. Hence the term constructive discharge. They construe, meaning they interpret your resignation to be involuntary constructive discharge. And you have the burden of putting up evidence to raise a non-frivolous argument that if the case were to go to a hearing, that you have a case that's even worthy of a hearing. You have to put up the evidence, you have to allege enough facts to show that it meets that high burden. Unpleasant working conditions and things of that nature just don't suffice, even if it's unpleasant or inconvenient. A lot of cases will get dismissed at that stage before they even proceed further. Once you get past that initial hurdle, then you can have your day in court with an MSPB hearing. You could either take it to the Federal Court of Appeals. If you are raising discrimination, it's a mixed case. You need to bring it to a federal district court. So you still have options. This is Kevin Crayon. It's been a pleasure. See you on the next episode.